a very broad overview of the differences between the federal and the state legal systems in helping folks understand the differences and that kind of stuff. I am joined with by Lord. I am joined with Ty, who will be moderating and doing that stuff. Do you want to say hello, Ty?
Good afternoon. I'm Ty, Advocate Support Program Manager. So today I will be helping with managing questions from you all, the participants. At any point during the webinar, should you have any questions, go ahead and type your question under the question tab, and then Rena, Rachel, and Amy, who are the presenters, will check in with me throughout their presentation for any questions, and they'll be happy to answer them as we go along. So before we actually start the webinar, though, I do have 2 poll questions, so the presenters can get a better understanding of the audience today. And what I'm going to do now is I'm going to go ahead and start the poll question, the first one, and if you can quick, answer, and then I will give the results. So how long have you been advocate? Please select one: less than a year, 2 to 5, 6 to 10, or 11 plus years. Okay, so I'm going to go ahead and close the poll. And the results are less than a year, 40%, 2 to 5 years, 40%, 6 to 10 years, 20%, and we have nobody on that has been there 11 plus years. So the second poll question. Okay, hang on a second. My computer is lagging. Perfect timing for my computer to lag. Okay, my computer won't take me back to that screen. So the second poll question basically was how many advocates are in your office? And so we just wanted to kind of know how big your organization was, but because my computer is frozen, it won't allow me to do that poll. I also want to let everybody know that at the end of the webinar, please just stay on for a little bit longer. We have a brief evaluation for the participants. We do love to and appreciate any feedback that you can give us. Your feedback helps us in so many ways, and we want to continue to provide quality and relevant webinars to all of you. And so before I have Rena start, I want to remind everyone that this webinar is being recorded. And if you haven't already subscribed to our YouTube page, Standpoint MN, please do so. All of our webinars are uploaded on our page, and as a subscriber, you will get notifications whenever we upload a new video. Okay, go ahead, Rena.
Thanks, Ty. I have a note on my computer that's saying that you have to hide the poll results to enable screen sharing. There we go.
There we go. Yep.
All right,
Because my
fantastic.
computer froze.
Hey, the wonders of technology.
Yep, this is live, y'all. This is live.
Yep, we're live. Thank you so much, Ty. So again, this is Raina Alexander. I'm the executive director here at Standpoint. And also with us today is Amy Larissella, who is our newest, or actually now she's our second newest hire, who handles employment and tort law. And then Rachel Kohler, who is our immigration attorney, will be speaking towards the end of this webinar. So you'll get to hear both of them. So like I said, the idea of this webinar was to really give kind of a high overarching understanding of the legal system and the differences between the federal and the state legal system. I often, I get calls from, a lot of this is inspired from, I'll get calls from advocates or from victims who are struggling to understand why law enforcement isn't doing X, why they aren't doing something. A big one I used to get a lot of calls about before Minnesota passed its own firearm prohibitions as it related to protective orders or to orders for protection, was it's illegal under federal law for somebody who has an order for protection against them in many circumstances to be able to possess a firearm. Why is my local law enforcement not doing something about it? Why aren't the police doing something about that? And the answer is because that's federal law, not state law. And our local police don't normally enforce federal law, they enforce state law, and they don't really have the authority to enforce federal law. And so that's kind of what gave the inspiration of talking about the two different systems and helping folks have a really just very broad, very general understanding of that we have both a federal and a state system. And most of the time, the two do not interact with each other. So we have the federal side of the courts, which is the United States Supreme Court, sometimes also referred to as SCOTUS, which is the Supreme Court of the United States. Under the that's the highest court, right, in the land, the highest court of the land. Under the United States Supreme Court on the federal side is then our Circuit Court of Appeals, and they're referred to often by numbers. So you may hear that Minnesota is in the 8th Circuit. You might have heard about the 9th Circuit, which is where California is, and people talk about how that's a very liberal circuit. You know, so the circuits are normally referred to as through their numbers. But that's kind of an intermediate appellate court. It's similar to Minnesota's Court of Appeals. And then the lowest level of the federal system are called district courts. They are similar to our trial courts here in Minnesota, right? And then in Minnesota, on our side, we have a trial court. We have an intermediate appellate court, which is what we refer to as our Court of Appeals. Folks may not know this, but we've only had a Court of Appeals for under 40 years. I know that it's been established since I was alive. And originally, Minnesota only had a Supreme Court, and we had no intermediate court. And then we have the Minnesota Supreme Court, which is our highest court here in Minnesota. How they label their names of their courts varies from state to state. For example, in New York, the highest court in New York is the New York Court of Appeals. And some places call their trial courts superior courts. So it's just going to vary from state to state. But in Minnesota, we have trial courts, we have the Court of Appeals, and we have the Minnesota Supreme Court. There are very limited circumstances, which we'll talk about, where if you are talking about state law or you are in a state court system where you could appeal up to the state court, to the highest state court, to the Minnesota Supreme Court, and then seek review from the United States Supreme Court. It's actually, there are pretty limited times when one can do that. We have this parallel system, and which system you end up in, whether you're in federal court or you are in state court, depends on the jurisdiction that the court has. And we've talked about jurisdiction before as it relates to what county can you file your order for protection in, right? You can only file your order for protection in the county that the petitioner lives in, or the county the respondent lives in, or where there's a county where there's a family court action, or where the abuse occurred, right? Those are the counties you can file in. The same idea, okay? So when you're trying to decide whether or not you have the federal court has jurisdiction or the state court has jurisdiction, in general, the answer is federal courts have jurisdiction over federal law. So anything that Congress is passing, any treaties, and they have jurisdiction over the United States Constitution, okay? State courts have jurisdiction over the state constitution and over our state laws. Okay, and so those are the ones that we think of that are passed by our legislature, right? And state courts do have jurisdiction to make decisions or rulings about the United States Constitution, but normally they're going to be following precedent and not setting new decisions. All right, but in general, federal courts are going to decide things on federal law issues. State courts are going to decide things on state law issues. Federal courts will almost never decide anything about a state law. And state courts are only going to be deciding things about anything on the federal side is the US Constitution. There are very rare cases where a state law could end up in federal court, and that's if what's something we call diversity of jurisdiction. And that's where you have the parties. So your respondent, your petitioner, and your respondent are from two different states, and normally it's two states fighting. And there has to be the money that's in controversy has to be over $75,000, right? So most of us are never going to be involved in some sort of federal case involving diversity. These are big corporations and that kind of stuff where that kind of thing happens. But those are the rare cases that you would end up in federal court dealing with state laws otherwise. And when those times when state or federal jurisdiction overlaps, in general, the plaintiff can choose which court they want to be in, but it can also be removed to another court. So the main things that I want you to know about kind of this parallel system between state and federal courts is that sometimes they overlap, but in general, they do not. State courts handle state law, federal courts handle federal law. And where the parties will end up, whether it be state or federal court, really depends on the issues that are being heard. And if you have a state case, and as long it's that for a state case that started on the state side, for it to end up at the United States Supreme Court is only going to be if there is a federal U.S. constitutional question. Otherwise, there's no ability to really remove it to the United States Supreme Court. So, for example, say I was appealing an order for protection, and I was arguing that my simple argument was that the district court abused its discretion in granting the order for protection because the district court did not find domestic abuse that occurred, and so they abused their discretion. All right, that's a question of state statute, right? It's a question about 518B, state statute only. I'm not making any federal constitutional arguments. Now, I probably could, but I'm not. And if I appeal it up to the Court of Appeals and I lose, and I seek review from the Minnesota Supreme Court and they granted it and I lose, I'm done. There is nowhere else I can go. I can't ask the United States Supreme Court to grant review to hear my solely state statute question, okay? So stepping back and going back to the federal courts, like I said, we have district courts, Court of Appeals, or the circuit courts, and then the United States Supreme Court. There are 84 district courts. Things to know about the federal court system: all the judges in the federal court system are nominated by the president and then affirmed by Congress, by the Senate, and they are lifetime appointments. So keeping that in mind, because that means that this is why the federal court system is so very important, and why there has been a lot of kerfuffle in the last recent years. Specifically, when Justice Scalia passed away, about fighting about who's going to get to decide who's going to appoint that justice. But it is also why it matters even at the district court level and even at the circuit court level, because these are judges that will sit for a lifetime. And that means, unlike in Minnesota, where we require our judges to retire at the age of 70, is not true on the federal side. Justice Stevens was in his 90s. I mean, so these are justices that can sit for a very, very long time. So we have our district courts. There are 94 district courts, and district courts, again, behave just like trial courts here in Minnesota. If you've got a dispute that involves federal law, that's your first court that you would file in. There is the U.S. Circuit Court of Appeals. There are 13 Circuit Court of Appeals across the state, across the country. Minnesota is in the 8th Circuit, which includes Arkansas, Iowa, Missouri, Nebraska, North Dakota, and South Dakota. And if you are unhappy with the decision that you got at the U.S. District Court, you can appeal it to the Circuit Court of Appeals. And that is, the Circuit Court of Appeals is what I often call an appellate court of right, which means you have the right and they have to hear your case. So you can always appeal up to them and they have to hear it. Above the Circuit Court of Appeals is the United States Supreme Court. It is our highest court in our judicial system. And the United States Supreme Court gets to decide what cases they want to hear. And they can choose to say no, or they can choose to say yes. And so the United States Supreme Court only hears a small fraction of the cases that are ever brought to the United States Supreme Court. The cases, again, that the United States Supreme Court is going to decide are going to be U.S. constitutional questions. And then I think they technically have some original jurisdiction as it relates to treason and piracy or something like that. I don't remember one or the other. There's a weird one that we never think about that technically the United States Supreme Court has original jurisdiction in. But otherwise, they're hearing all cases that are appealed up from the Circuit Court of Appeals. So obviously, as folks remember from their classes in elementary and junior high and high school, our federal courts are part of the judicial branch. And Article 3 creates our judicial branch and creates the United States Supreme Court, and then gives Congress the authority to create further lower federal courts, which they have. We talked about how they're appointed by the president, or they're nominated by the president, and Congress approves them, and they hold their position for life, but they could be removed by Congress for misbehavior. I have no idea if that's ever happened before. Federal courts deal with United States constitutional questions, federal laws and treaties. They also handle disputes between 2 or more states. They are also where our bankruptcy law is. Bankruptcy is federal law, and so is immigration. Immigration falls under our federal laws. Okay, so those are, we'd have a bankruptcy court and we have immigration court, and those are all on the federal side. And then again, the federal court can hear stuff if there's diversity of jurisdiction and $75,000 in dispute. I've been having the hardest time with numbers lately, you guys. I don't even know what to tell you. Staff was laughing at me on Tuesday. I couldn't. So that is our federal courts. People inside of our federal courts are federal prosecution. These folks actually belong to our executive branch, but on the federal side, the feds have their own prosecution. And prosecution occurs through the United States Attorney's Office. So you might have heard of somebody referring to themselves as a USA. We are not referring to the United States of America. We're referring to United States attorneys. And these are folks who represent the federal government at all levels of the federal court system. So district court, the circuit court, or the United States Supreme Court. We have 93 U.S. attorneys. There's 1 for every federal district except for Guam, and a few and another and Northern Marianas. The U.S. attorneys are appointed by the president, which makes everything very, very interesting because when the president, when we had a presidential turnover, when Obama left office and Trump was elected into office. Often when that happens, when you have a change in administration like that, the U.S. attorneys will often, the head U.S. attorney will often leave. That is true here in Minnesota. It was Andy Lugar who was appointed by President Obama, and Andy Lugar stepped down as the U.S. attorney for Minnesota. And currently, well, we ran around for a while without any head U.S. attorney, and currently Gregory Brooker is our interim U.S. attorney for Minnesota. Just in case anybody's wondering. So the U.S. Attorney is the chief prosecutor in criminal cases, represents the U.S., where the U.S. is, and also represents the U.S. when we are when the United States itself is being sued. They are not the people who do the investigations. That's normally going to be carried out by the FBI or the DEA or any other number of those of federal law enforcement. Their job is to prosecute cases on the federal side. So you can see that here in Minnesota, we have one U.S. attorney. That is not true for all states. Wisconsin has two, and even Iowa has two. How did Minnesota only end up with one? Who knows? But we only have one U.S. attorney. Something else to think about under federal prosecution that sometimes we forget about in Minnesota is tribes who are non-PL 280. Like Red Lake, like Bois Forte, and now White Earth has joint jurisdiction. They are also under federal law, and so it would be the U.S. Attorney's Office and the Bureau of Indian Affairs that would handle prosecutions and investigations on those tribal lands. Our other tribes in Minnesota are PL 280, and PL stands for Public Law 280. And I'm not trying to get into a big discussion about tribal law because that's a way different webinar. But just know that our PL 280 tribes, they would not be covered under the federal laws and statutes, that they are covered under state law. So in Minnesota, we have one U.S. attorney. And there are about 125 people who work in our U.S. Attorney's Office. Our U.S. Attorney does also have victim witness advocates. So if somebody is ever a victim in a federal crime, there are victim witness advocates, and their headquarters is located in Minneapolis and St. Paul. All right, so that's the federal side. Ty, did anybody have any questions about the federal court or federal prosecution?
No, there was no questions.
Great, because I'm sure it's super clear. All right, so we're going to leave the federal system aside for a moment, and we're going to go over to the state court system. So this is Minnesota's system, and this is how Minnesota has arranged their system. So the lowest court in Minnesota is your conciliation court or small claims court. And this is a place where it's very, very friendly to folks who are not represented. And as a matter of fact, most of the magistrates who sit in conciliation court do not want to see attorneys in there. Your conciliation court is meant when you are seeking money claims of $15,000 or less. This can be to get security deposits back, unpaid wages. It's really meant to get money. It is not a very good place to try to get ownership of personal property, although they might do it sometimes, but it's really the best is to just get money. So you have your conciliation court. If you were ever unhappy with what happened in conciliation court, you can seek review from the district court. You can remove it up to district court or our trial courts here in Minnesota. But most folks are hanging out in the trial court, right? That's where all of our civil actions, our criminal actions, our family law, our juvenile law, violations of city ordinances, all of that's going to happen in our district courts. This is where we see, our order for protections are going to happen there. We have 10 districts that each encompasses a number of counties, right? So we have our county trial courts. We have 10 districts in Minnesota. And then there are 289 judgeships. Things to note about judges in Minnesota. In general, judges in Minnesota are initially appointed by the governor, and then they are elected. And judges are elected for 6-year terms. And if a judge leaves in the middle of their term, if they retire, and they have to retire in Minnesota at the age of 70, they can become one of those retired judges that work the circuit and they just go all over the state. But they have to retire as a non-retired judge at the age of 70. I totally just lost. So they're appointed for 6 years. If the judge retires or steps down from the bench in the middle of that 6 years, that is when the governor, through a task force, there's a task force that makes recommendations to the governor will then make an appointment. And so say the judge retired 3 years into their 6-year term, the person will be appointed. So a new judge will be appointed by the governor, and then to finish out that 6-year term, so they will be a judge for 3 years, and then they will have to run and be elected. So judges, we have a kind of a weird thing in Minnesota where judges are mostly appointed, but they also can be elected. It is unusual, although it does happen, where a sitting judge in their election, when they go to be elected, is unseated by somebody who is not a current judge. It's unusual, but it can happen. So keep that in mind. If, not that I'm saying we want to get rid of any judges in Minnesota. I'm sure they're all lovely and wonderful. But, if that a time ever came about, they are elected ultimately. And, as people, as the electorate, we can vote them out of office. All of our judges in Minnesota are appointed and then elected in that way. That includes our trial court judges, it includes our Court of Appeals, and it includes the Minnesota Supreme Court. So if you are unhappy with what happened at the district court level or the trial court level here in Minnesota, you can appeal your case up to the Minnesota Court of Appeals. The Minnesota Court of Appeals, similar to the Federal Circuit Court, is an appellate court of right. You can always appeal your decision up to the Minnesota Court of Appeals. Will you win is another issue, but you can always appeal. And so the Minnesota Court of Appeals gets appeals from the trial court. They also take direct appeals from the Commissioner of Economic Security and from other administrative agencies. You kind of can see that there's administrative agencies off to the side here, which is interesting. And others, so the unemployment, like if you seek unemployment and you get denied, you can have an unemployment hearing. Or the same thing happens with public benefits or in other types of circumstances, employment law too. You have a hearing in front of administrative law judge who makes a decision. But if you are unhappy with the decision by the administrative law judge, if you're unhappy with the decision about your unemployment, or you're unhappy about the decision from the Equal Employment Commission here in Minnesota, and you want to appeal that decision, you actually appeal it directly to the Court of Appeals. It doesn't go up through the district court then, which is unusual for a lot of states. So you go to a direct Court of Appeals appeal. Court of Appeals also hears things like writs of mandamus or prohibition. Those are a specific type of appeal. Or if there's a public official, or if you got some problems there. There are 19 members total of the Minnesota Court of Appeals, and they sit in 3-member panels on an appeal. If one is unhappy with what happened at the Court of Appeals and you want to appeal up to the Minnesota Supreme Court, the Minnesota Supreme Court is not a court of appeal of right, and they get to choose what cases they want to hear. So you ask for review from the Minnesota Supreme Court, and they can say yes or they can say no. Except for they hear all first-degree murder conviction appeals, and that goes straight from the trial court up to the Minnesota Supreme Court, which may be why you see, if you ever follow decisions out of the Minnesota Supreme Court, why you see all of these appeals that happen from first-degree murders, because it's an automatic appeal. And they also hear some other things as they get appealed up through the Court of Appeals. So that's the Minnesota Supreme Court. You can see our 10 districts here. Those are, so we have them, so we have our districts, and then those are broken down by counties. Obviously, we know we have our counties. 4th district is Hennepin County, and the 2nd district is Ramsey County. Hennepin and Ramsey are broken down into smaller court divisions like civil court, criminal and traffic court, family court. But when you get out outside of the metropolitan area, our courts are more of a hodgepodge. They aren't necessarily breaking it down by family court or criminal court in the same way that Hennepin or Ramsey are, especially in some of our counties where you either have a judge or you only get a judge that shows up like in Cook County like every other week for a couple of days. Obviously that's a judge that's hearing everything, and there is no distinction between family court and civil court or criminal court. I mean, there is a distinction because the rules are different, but who's hearing it and how it's happening is all going to happen in one courtroom, right? So the Minnesota Court of Appeals, like I said, they are an error correcting court. And what that means is the Minnesota Court of Appeals is not a new trial. They are not another set of judges to go and plead your case to. That is not the role of the Minnesota Court of Appeals. The role of the Minnesota Court of Appeals is to determine whether the lower court, the trial court, made a mistake in rule or law. The Minnesota Court of Appeals very, very rarely will overturn a decision by the district court that was based on credibility. They always leave credibility to the district court. So if somebody is testifying, say, in an order for protection, and the district court or the trial court does not finds the respondent is not credible. All right, and that's the reason. And the court's going to say that they believe domestic abuse happened. They found the petitioner was credible and the respondent was not credible, and then makes their findings of what domestic abuse occurred. That would be a circumstance. The respondent can try to appeal. You can always appeal. You can always appeal, but unless something really wackadoo happened in that hearing, and the Court of Appeals is not going to overturn that decision because it was based on credibility. And the district court always gets to make credibility determinations because they're the ones watching the parties. They're the ones who are hearing the direct evidence. They get to see the look on your face and your behaviors and how you're hand gesturing and the tears, and they get to see all of that. Whereas the Court of Appeals, all they get to see is they get to see the court's order. They get to see any evidence that was introduced. They get to read the transcript, and they get to then also read any the motions or the briefs that are written to the Court of Appeals about why the district court made a mistake. It is not a place where you get a new trial. You're not going to be able to present new witnesses. You don't get to present new evidence. There are only going to be oral arguments if both sides are represented by counsel. If one side is not, you will not get oral arguments. Everything is largely going to be based on in writing, and the court's going to be basing its decision based on what happened at the district court, and they're looking at, did the district court make a mistake either in applying a rule, like a rule of criminal procedure, a rule of evidence, a rule of civil procedure, or did they make a mistake in applying the statute? That's what they're looking at. In Minnesota, our Court of Appeals can issue what are called published, or they can issue unpublished cases. And so sometimes I know at new laws, we talk about published versus unpublished all the time. So a published case should be cases that we often are going to be cases we refer to as precedential setting, which means that the lower court can or should use them in making its decisions going forward. These are cases, published decisions are going to be cases that are normally setting new law. They may be making a decision about a statute that has never been made before. It may have a constitutional argument, but normally these cases are going to be published where it's something novel, something the Court of Appeals has not ruled on before, something the Minnesota Supreme Court has not ruled on before, because there's no reason to make a precedential setting case if there's already precedent out there, unless the court is changing its mind and overturning an old case. Cases that are more rote that you see all the time, the facts are very specific, or the court, for whatever reason, is uncomfortable in setting a precedent with that decision, which I see sometimes where like both the parties are unrepresented. The court may be uncomfortable in trying to set some sort of precedent where it feels like all of the issues may not have been briefed as well as they possibly could have been, but they have to issue a decision. That's where the Court of Appeals, will issue what's called an unpublished case. And those cases are not precedential setting. They are merely advisory to the trial court. So the trial court can follow what the Court of Appeals did, or they cannot. It's up to the lower court. Precedential setting opinions are binding on the lower court, on the trial court, and they have to follow those decisions unless they can come up with a really good reason why the Court of Appeals was wrong. So that's kind of the difference between published versus unpublished. The vast majority of cases in Minnesota are going to be unpublished out of the Court of Appeals. These are cases that, and the court is often writing these decisions. They're shorter, and they maybe have a little less thought process put into them because it's already been decided, or the rule of law has already been decided. So that's the Minnesota Court of Appeals. Court of Appeals is Minnesota Court of Appeals, Court of Appeal right. You can appeal anything. For the most ridiculous reason, and the Minnesota Court of Appeals has to issue a decision, and they may not be happy about it, but like, I could declare that people who wear purple pants are breaking the law, and then I try to sue somebody who's wearing purple pants, and of course my lawsuit is going to be thrown out at a motion to dismiss because I don't get to set laws that say that people can't wear purple pants. And if I am unhappy that my lawsuit was thrown out, I can appeal that to the Court of Appeals, and the Court of Appeals has to issue a decision saying that my case gets thrown out at a motion to dismiss because I don't get to declare that people have to wear purple pants. The Minnesota Supreme Court, that is not true. The Minnesota Supreme Court is not an appellate court of right. They are a court, just like the United States Supreme Court, that gets to decide which cases they're going to consider. And the Minnesota Supreme Court only accepts about 10% of those cases that are asked for review. And you have to prove to the court why you want review. And so normally it's issues of, do we have trial courts doing different things? Do we have judges with different opinions? Is this a major constitutional issue that needs to be addressed? Did the Court of Appeals really make a mistake? So you have to be able to prove to the Supreme Court why they need to hear that case. Again, in general, the Minnesota Supreme Court is a court of last resort if we are talking about solely Minnesota issues. So Minnesota Constitution, Minnesota statutes, Minnesota rules. And so the only way you get past the Minnesota Supreme Court is if you have a United States constitutional question. Supreme Court justice we have 7 of them here in Minnesota. Right now we are running on 6 because one of our justices was appointed to the federal bench. So right now we have 6, but we are in the process of getting another justice. So they are appointed again by the governor, and then after that, then they're elected for 6-year terms. They have to be lawyers, but they can't practice law while they're on the bench, which is true for all judges in Minnesota. So gotta be a lawyer. Sorry, guys. If you want to be a judge, you got to be a lawyer first. Minnesota also has those administrative courts, which you saw on our slide. They were kind of off to the side there. And they carry out hearings, and they often mediate involving kind of public or local government type issues. Includes things like workers' compensation, fair campaign practices, licensing for childcare or foster care. It also includes things like unemployment benefits, and some employment stuff happens through an administrative process. Largely in that, you don't need an attorney, is not necessary, but the government will be represented by a government attorney. And those orders can then be appealed up to the Minnesota Court of Appeals if you're unhappy with them. So on the prosecution side of our court system, we have a tiered prosecution here in Minnesota. First of all, we have the Minnesota Attorney General, and that's Lori Swanson right now. And the Attorney General is an elected official. We elect them as the population of Minnesota. And she represents all government agencies and commissions at both in state and federal court for the state of Minnesota. She also provides her office provides assistance to the county in cases involving major felonies. So you will often see, especially if you're in a smaller county and you have a first degree or second degree murder, sometimes the AG will help actually in the initial prosecution. They regularly will take that case up and if they're going to appeal it, and it's the AG's office that actually does the appeal in concert with the county attorney. But on these big appeals, out of your county prosecutor's office, it's regularly the AG if you're in a smaller county. The Attorney General's office also holds businesses and corporations accountable. You have to, if you have any complaints about how a business or corporation, including nonprofits, are being run, you can make a complaint to the AG's office. I always like to encourage people, like I have complained to the AG's office personally about Comcast twice. The AG's office in Minnesota is amazing, and Comcast paid immediate attention to my concerns. So again, they really do some great stuff around fraud and consumer protection. So I always like to encourage people, use your AG, use the AG's office, because that's one of the things they're there for, and they are actually pretty responsive. So, you know, you're ticked off at your internet provider because they did something that seemed really shady, report it to your AG's office. It's a good thing. So first of all, we have our AG's office, and then every county has their own county attorney. This is also an elected position, right? So county attorneys in Minnesota are elected every 4 years. Every county has a county attorney, so we have 87 county attorneys, and it is divided into many county attorneys, depending on the size of their office, are going to be divided into criminal, civil, juvenile, and it could be more or less depending on the size and the needs of the county. They also have their own staff. They have victim witness advocates, or the vast majority of our counties have victim witness advocates. They are there to, on the civil side, represent the county. They advise the board or county officials. So they advise your sheriff in your county attorney advises your sheriff on legalities of things. They're there to prosecute felonies. They take care and initiate grand juries, and they also initiate all child in need of protective services or stuff on the juvenile side. Depending on how rural your community is, the county attorney may also be the one who's handling misdemeanors and gross misdemeanors for your city or town if you are a city or town that does not have a city prosecutor. And the vast majority of our cities, our small cities, do not have their own city prosecutor. So the county attorney handles those things. You can kind of think of the county attorney as like in-house counsel for the county. They're going to give legal advice. They're going to represent the county if the county, they're going to do negotiations for the county. But they're also on the criminal side. They're going to prosecute felonies for the county. Then finally, on the prosecution side in Minnesota, we have city prosecutors. So when I first moved to Minnesota back a number of years ago now, 15 years ago, I went to law school out in Boston, and Boston has a different way that they structure their prosecution. And it took me a really long time to figure out that there's a difference between city attorneys and county attorneys, and what it is the difference, and how, like, what they prosecute and all that kind of stuff. So don't feel bad if you didn't know, because I certainly didn't, and it took me a while to figure it out. City attorneys in Minnesota are appointed by the mayor. Like I said before, not all cities and towns have city attorneys. And some are appointed by the mayor, some are appointed by the city council. So if you, unlike your county attorney, if you're unhappy with your county attorney, you can vote your county attorney out. If you're unhappy with the AG's office, you can vote your AG out. If you are unhappy with your city attorney, then that means you got to start lobbying your city council, because they're the only ones who can get rid of your city attorney. But I'm sure all your city attorneys are fantastic and wonderful. Many cities contract out, especially our smaller cities down here in the metro. They will contract out to a firm who has an attorney who is doing city attorney work. So they may not actually have a city attorney's office, quote unquote, like a formal office that people can go to. It's really going to be part of a, it will be part of somebody's law firm. City attorney is divided into criminal and civil divisions. Some city attorneys have victim witness advocates, most do not. But for example, here in Minneapolis, they're going to represent the city. They're going to prosecute petty misdemeanors, gross misdemeanors, but they're only going to do so as it relates to adults. It's the county that handles all juvenile stuff, and then it's the county that's also going to handle any felonies. All right, so in general, if you have a city attorney, your city attorney is going to be handling misdemeanors and gross misdemeanors, so violations of OFPs, 5th degree assault, domestic assault, right? Misdemeanors, gross misdemeanors. Your county attorney is going to be handling felonies. Unless you are in a community that does not have a city attorney, then your county attorney is going to handle all of it. All right. Ty, do we have any questions about the state side of the justice system?
Yeah, so we just have one question, and the question is, where do we go with victims' complaints? Complaints with the prosecutors.
Oh, if somebody has a complaint about the prosecutor, I guess, so it depends on exactly what the complaint is. I would, part of our role as advocacy, especially, is to develop relationships with the prosecutor's office whenever possible. So I would always say, you know, first of all, go to your individual prosecutor if there's a problem and see if you can have a conversation. If that's not working, you know, in most cities or in counties, the individual prosecutor that you're working with, that, you know, they're going to have supervision, whether, you know, depending on the size of their office, there may be some levels of supervision, or it may be your county attorney, depending on the size of your office, or your city attorney. So depending, you may need to work your way up and who you're going to have those conversations with. And again, these are all people to work on creating good, solid relationships with, because if there are concerns, you want to be able to talk to them. I always encourage folks to develop those relationships before there are any problems, because it's not fun to try to start to develop a relationship when all of a sudden there is a problem. If there are concerns about crime victim rights, as enumerated in Minnesota Statute 611A, you can always make a complaint to the Minnesota Crime Victims Justice Unit. That's Susan Elwell over at OJP, and they can investigate and they can make recommendations. However, they have no authority to remove a prosecutor. If you've got a problem with an assistant prosecutor, whether it be a city or a county, the only people who can remove them is the county attorney or the city attorney. And the only people who can remove the county prosecutor, the county attorney, is the people of the county by voting them out, or some sort of impeachment process. And the only way you can get rid of your city attorney is for your city council to remove them. So hopefully that was helpful. Make relationships and be friends with your prosecutors. Then you can talk to them if there's a problem.
Yeah, so there's another question, Rena. So what if your city attorney is contracted out? Would complaints go to the city council?
I would say, again, I would figure out if, you know, again, have that relationship with your city attorney, if at all possible, have that conversation with them. If there is no supervision above that person, and there may not be, then yeah, your complaints go to the city council.
All right.
Any other questions, Ty?
Nope, that was all.
All right, great. Okay, so we've talked about federal and state courts. We've talked about federal and state prosecution. Now we're going to talk about federal and state law enforcement. Okay, law enforcement is not part of the judicial branch. Neither are prosecutors, by the way. We just had this very intense conversation in our office about our prosecutors, the executive branch or the judicial branch. And we had to decide that I lost, and they are part of the executive branch. But law enforcement is also part of the executive branch. Okay, so under the executive branch and under law enforcement, on the federal side, you have the president and federal law enforcement, and their job is to enforce federal law. On the state side, under the executive branch, you have the governor and you have state law enforcement, and their job is to enforce state laws. And in general, none shall the two mix. This is why as lawyers we often get so concerned about this idea of our local law enforcement trying to enforce immigration law, which is federal, because our local law enforcement don't enforce federal laws. Local law enforcement is guided. They can't violate the United States Constitution, but their role is to enforce state law. So then we also have the judicial branch, right? We got the federal judicial branch, which is the U.S. Supreme Court and the federal courts. Their job is to interpret federal laws. Okay, and then we have our state side of our judicial branch, and that's going to be the Minnesota Supreme Court and the Minnesota Court of Appeals and the trial court, and their job is to interpret state laws, right? So separate systems, they don't squish together. Federal law enforcement, there are so many federal law enforcement agencies. It always blows my mind when I start thinking about it. And each individual department has their own federal agency that their own federal law enforcement. So you have the CIA, right, which is the law enforcement for the executive office, for the president. People think that's the Secret Service, but what's really funny is they actually are the law enforcement agency for the Department of the Treasury. Go figure. You also have the Federal Bureau of Investigations. They are law enforcement for the Department of Justice. You have Immigration and Customs Enforcement. They work under the Department of Homeland Security, right? And then there's like, you know, you can have the ATF, which is alcohol, tobacco, and firearms. They do a whole certain set of things. There is the DEA, which is drug enforcement. They do a different set of things that seem very similar to the alcohol and firearms folks, but they're different, I promise. So there's lots of different federal agencies, and they have very specific things that they do. But they enforce federal law. And I drive my partner absolutely nuts when we're watching a TV show. We were watching a TV show, and there was a federal agent who happened to be based out of Seattle, and he was citing Washington state law. And I was like, what is an FBI agent doing citing Washington state law? Like, that means nothing to an FBI agent. It doesn't matter. His job is to enforce federal law, not Washington state law. And my partner shushed me. Probably appropriately, because he's so tired of hearing me say these things. So federal law is there to act upon the laws of the United States. They investigate the laws of the United States, and they help. They will also provide support and get that information to prosecutions, to the U.S. Attorney's Office, to then prosecute. And then there's some more examples of federal law enforcement agencies, and they do overlap with each other, right? I mean, obviously Border Patrol overlaps with Transportation Security, right? The TSA, because they're doing somewhat similar things, but still somewhat different things. So sometimes they overlap, but they do all each have individual responsibilities. State law enforcement. So under the United States Constitution, the 10th Amendment, it leaves all powers to the state that are not otherwise enumerated. And so that means that the state, anything that's not federal law, the states get to take care of. And so that's how states end up enforcing. That's why states enforce state law. They enforce state constitutions. In state law enforcement, and normally you have the governor, and then they appoint your various heads, or they're elected heads of state, like the state auditor in Minnesota is elected, the attorney general is elected, your secretary of state is elected, your lieutenant governor is technically elected until they go off to become a senator, and then that gets more complicated, right? Below them are things like the Department of Commerce, the Department of Corrections, et cetera. There's a whole bunch of agencies. Those folks are then appointed. Who their heads are appointed, not elected. So in Minnesota, under law enforcement, we have state, county, and city law enforcement officers, right? Under our state law enforcement, we have the Department of Corrections, falls technically under law enforcement. We have the Minnesota Department of Public Safety, which includes things like the BCA, the Bureau of Criminal Apprehension, also includes the fire marshals, also includes State Patrol, right? So our lovely State Patrol, which always reminds me, don't speed in Lake or Cook County. And then also the Minnesota Department of Natural Resources is a state law enforcement agency, okay? In case you were ever wondering, here are the Minnesota State Patrol districts as defined. So you can see they follow county lines and they break up into a number of different districts. So then we have county law enforcement, and that's our sheriff's department. Every county has a sheriff's office. There's 87 of them in Minnesota, and the sheriff is elected. That is a position that you within your county, you elect your sheriff. Sheriff does a variety of things. The sheriff is going to provide law enforcement across your county, depending on if your city may not have local city police, which in rural communities is really common where they don't. And so your sheriff's department is going to be providing all of your law enforcement needs. They are also the ones who provide the vast majority of service. So they're going to be serving your protective orders, orders of protection, harassment restraining orders. They're going to be providing service of other court orders. They are also the ones who are responsible for security at the courthouse. This happens through your sheriff's department. So that's the sheriff's department. Then you have your police departments. In Minnesota, we have 321 municipal police departments. So that's 321 cities that have a police department. And 8 non-municipal, that's like the University of Minnesota has their own police department, and nine of our tribes have their own police departments. So while your sheriff is elected, so if you don't like your sheriff, you can vote your sheriff out. Unlike your sheriff, your chief of police is appointed. And that's going to be appointed either by the mayor or is going to be appointed by your city council. I know this says in Hennepin County, it should actually be Minneapolis, because Hennepin County has a sheriff because it's a county. Sheriffs cover counties, police cover cities. So I apologize for my typo. But the city of Minneapolis, it's appointed by the mayor. So sheriffs cover counties, police cover cities, but again, not all cities and the vast majority of cities do not have local police, and so the sheriff's department provides that law enforcement. But the police in general, that is what you think of. They do patrol, they respond to emergency and non-emergency cases, they take statements at crime scenes, they recover evidence. You know, they do what you think of as your regular police work, and that's what your local police department is doing, in addition to your sheriff's department in many places. All right. Hey, Tide, are there any questions about police departments?
No.
No. All right. Well, I'm going to hand this over to Rachel about immigration, and then after that we'll have Amy. But I'm going to let Rachel talk about immigration here.
Awesome. Can you hear me?
I can hear you.
Okay. All right. Great. I've successfully unmuted myself. So my name is Rachel Kohler. I'm a staff attorney at Standpoint, and one of my main areas of focus is in immigration law. So I'm going to take over and talk a little bit about the immigration law system and kind of how it all fits in. This slide has a lot of words on it. What it's basically saying is under the Constitution, immigration law is passed by Congress. It is passed by a federal agency. So if a state law passes, or a state government entity passes a law that conflicts with the federal government would win. I don't typically see too many state laws conflicting with immigration law because it is really a federal law system. But Congress is the agency that passes laws, which are then codified in the INA or the United States Code. And so a lot of people, especially in the last year, have had a lot of questions around how much power does the president have to change immigration law. The president does have some power. as we've seen, President Obama, through executive order, had passed something called the Deferred Action for Childhood Arrivals, or the DREAM Act. And that was all done through executive action. That was not done through Congress. It was never codified. It was never a permanent law in the Immigration and Nationality Act. And so when another president took over, that president then had the power to take that back or revoke that law. So while presidents have some power, they do not have power to codify or create permanent immigration law. So for example, after the Deferred Action for Childhood Arrivals was taken back, or is at least in the process of being rescinded, lots of my clients, lots of advocates contacted me and were concerned around, is this administration going to get rid of the U visa or get rid of the Violence Against Women Act self-petition? Are we have clients that have pending applications. If it goes away, what happens to their cases? Well, the president does not have the power to just get rid of law that is codified and has been passed by Congress. So I tell them, unless Congress takes this on and talks about rescinding that law from the codified INA statute, it's not likely to be taken away. It doesn't mean that Congress doesn't amend the INA or doesn't change immigration law, but it would be a much bigger deal, and we would be hearing a lot more if they were considering just getting rid of whole forms of relief. You can go to the next slide, Raina. Okay, so now I'm going to talk a little bit about the enforcement and adjudication part of the immigration branch. All of that is housed under the Department of Homeland Security. And under the DHS branch, it has several different agencies that work under it, which includes the U.S. Citizenship and Immigration Services, or USCIS. Anytime you're working with a client who is going to affirmatively apply for something, and when I say affirmatively, I mean they aren't necessarily going through the process of deportation or removal proceedings. They are applying for this on their own. They're not necessarily in court right now. They're applying for it affirmatively, not defensively. All of those affirmative applications would be processed by the United States Citizenship and Immigration Services, and they have 4 service centers located throughout the United States. Let's see if I can remember them all. California, Vermont, Texas, and Nebraska. Nailed it. So those are the 4 service centers that will process your applications. A lot of my clients get confused because they think, especially when they're reaching a deadline, they think that they can go to the immigration court here or even go to the USCIS office here in St. Paul or Bloomington and file their application there and get it processed there. That's not how it works. This needs to be sent to one of the 4 service centers, all located in the 4 locations that I stated, and it needs to be processed there. They then might decide that there needs to be an interview done. In citizenship, there are always interviews. Oftentimes in green card applications, there are interviews. Those would then, after adjudicating at a service center, would be sent to a local office. Also, under the Department of Homeland Security is U.S. Customs and Border Protection, or CBP. Raina already talked about CBP a little bit. These are the agents that carry out inspections at the port of entry. So if you're working with a client that was apprehended at the border, it's probably by a CBP agent. They also handle drug trafficking and human trafficking. The U.S. Immigration and Customs Enforcement is probably the enforcement agency most people are familiar with, also called ICE. They handle the investigation and enforcement of immigration law. This is the agency that would carry out arrests and would initiate deportation proceedings against a person. And then the last agency listed on here is the Administrative Appeals Office. So if you file something with USCIS, if you file a U visa application and they deny it and you are displeased with this, you would appeal that to the AAO. It's a different appellate structure than when you're in front of an immigration judge. If you're unhappy with the decision that the AAO makes, you would then appeal that to a federal court. You can go ahead to the next slide. Okay, so this is, I get a lot of questions about this. This is where it gets a little confusing. So there are several different agencies, several different policing units that can kind of filter into immigration enforcement. but they all kind of have different goals. So on the top left side, you're going to see state and local police can arrest a person for an offense unrelated to immigration status. Important to note that. So if I'm walking on the street, I don't have documented status, a St. Paul police officer can't walk up to me and say, "Are you undocumented?" and I say yes, and they arrest me because I'm undocumented. They cannot arrest me for an immigration reason. However, if state or local police arrest me for violating a law of that jurisdiction, for example, a traffic violation, they could arrest me for that reason. And then once I'm in their custody, the department could choose to share my status if they discover that I'm undocumented. They could choose to share that status with ICE or Immigration and Customs Enforcement. And then ICE would choose at that time whether or not they want to initiate any proceedings against the person. You may have heard of immigration detainers. What those are is if state or local police officers arrest somebody and they are in state or local police custody, ICE can issue what they call an immigration detainer, which asks the state or local police department to hold that person for a certain amount of time so that ICE can come and decide whether or not they want to transfer them into immigration custody. On the upper right side, you can see that a Border Patrol agent would arrest a person if they were crossing the border or entering through an airport unlawfully. And then at that point, if they decide to initiate removal proceedings against that person, they would turn them over to ICE. And of course, on the bottom part, ICE can always make arrests on their own. And then at that point in time, they'll decide whether or not they're going to initiate immigration proceedings, which brings us to our next slide. So as I was saying, after ICE arrests an individual, once that individual is detained, ICE will determine whether or not to initiate the removal proceedings. And they would do that by issuing something called a notice to appear or an NTA. That's kind of like the charging document that starts removal proceedings. Then at that time, if you've received an NTA, you will also receive a date in which to appear in front of an immigration judge. It is important to note that an immigration judge is not an officer of Immigration and Customs Enforcement. So they are not part of the same agency at all. ICE is who executes the laws. An immigration judge is the judicial part of it that interprets immigration law. At that point in time, when you first are arrested and detained and appear in front of an immigration judge, the judge will determine whether or not you should remain in immigration detention or if they should release you on bond. And an immigration officer, an immigration judge can choose not to allow you bond. And in fact, we're seeing that happening a lot more nowadays. And you can go ahead and move to the next slide, Raina. Okay, so this is kind of a pivot from what I was talking about before. This has to do with the branch of government that handles what we call consular processing. Consular processing is basically anybody who comes into the country or leaves the country, they would go through consular processing. And all of that is done under the State Department. So they have two main roles in implementing immigration policy. First, anytime a person is applying for an immigrant visa or a non-immigrant visa, they would go through what I put here as the Visa Information Center, typically called the National Visa Center. So oftentimes if you have clients who are petitioning to bring family members in, or maybe you have a friend who's abroad who's coming, to visit you and wants to get a visitor visa, they would go through the National Visa Center, which is part of the State Department. The State Department also controls refugees who come in through the Bureau of Population, Refugees, and Migration. I threw this in here just to let you know that that process is different than working with United States Citizenship and Immigration Services. It's a whole different department that really deals with the numbers of people coming into the country and leaving. You can go ahead and go to the next slide, Raina. All right, so to talk a little bit about the court process, all of immigration courts are housed under the Department of Justice's Executive Office of Immigration Review, EOIR, or lots of immigration attorneys call it EOR. Choose as you wish. So they adjudicate immigration cases and administer U.S. immigration law. Housed under the Office of Immigration Review is the Office of the Chief Administration Judge or Immigration Judge, who we would call IJs, immigration judges. These are the people that you're going to appear in front of when you have notice to appears issued against you and removal proceedings have been initiated against you. If an immigration judge issues an opinion that you are unhappy with and want to appeal, you would then appeal that to the Board of Immigration Appeals. And I put on there the Office of Chief Administration Hearing Officers. That's the office that would oversee immigration judges. If you are displeased with a decision of the Board of Immigration Appeals, typically you would appeal that to a federal court, which Raina has already talked about. In Minnesota, that would be the 8th Circuit. Occasionally, and I really do mean occasionally, the Attorney General can review decisions of the BIA, but either they have to, on their own onus, take on the case, or it needs to be referred to them by DHS or the board. So it's not typical that an Attorney General would take on a case after the BIA. Typically, you would appeal that then to the 8th Circuit Court. If you go to the next slide, Raina, it's a better sort of picture of what the appeals process would look like. So first you would start at the immigration court. In the United States, there are 54 courts. Our court is located in Bloomington, and Bloomington court covers Minnesota, the Dakotas, Iowa. It covers a big area. And so really, in the state of Minnesota, we're lucky that we have our immigration court housed in our state. Because it can often be very difficult for people to appear in court when they live in the southern part of Iowa or heck, the eastern part of North Dakota. It can be quite a drive to get to the Bloomington Immigration Court. So if you're unhappy with an IJ's decision, you would appeal that to the Board of Immigration Appeals. There's only one Board of Immigration Appeals. They're very, very, very busy people. They're located in Northern Virginia. And I want to say there's 12 panelists on the Board of Immigration Appeals. And if you are unhappy with a Board of Immigration Appeals decision, as I've already stated, you would appeal that to the Federal Court of Appeals. In Minnesota, that would be the 8th Circuit, although there are 11 courts located in the United States as a whole. And if you are unhappy with the decision of the 8th Circuit Court, you would then go to the U.S. Supreme Court, who may or may not take your case. And I think that's all I have to say about the immigration system. Ty, are there any questions?
Maybe you could just clarify, Rachel. So I have a participant asking about if the abuser is undocumented, would it affect the victim in going through the process of getting documentation? I don't know if you have time for that, or do you want to?
Okay, so I'm sorry. Repeat your question again. So you're saying if the abuser is undocumented?
Yes, if the abuser is an immigrant, and so I was trying to figure out by immigrant, do they mean not a citizen, or undocumented, right? And I'm thinking it hasn't been clarified for me. So undocumented, okay. Just got the message.
I mean, what I will tell you, and I don't know if this is really an answer to the question that they're posing, where I run into a lot of issues with victims who are calling me and want to get an order for protection or want to press charges against their abuser, they may be held back from doing so because they're afraid of what those criminal charges might do to their abuser's legal status. While they don't want to be abused by their abuser, they may also not want that person to be removed. It may be a source of financial stability for them. They may be the parent of their child. And so you really do have to have the conversation with your client about the fact that, yes, it's true, there are certain criminal charges that could affect your partner or your abuser's status. The victim's status should not matter in relation to whether or not they are contacting police or pursuing charges. Does that answer the question, Ty?
Yes, she said that. Yes, you did answer it. Thank you.
Lovely. Any other questions?
No, that was it.
Okay, I'm going to clumsily hand my set over to Amy, and she's going to talk about some employment stuff.
Hi, all. Can everyone hear me?
Yes.
Well, meaning Raina and Ty? Yeah. So my name is
Yes.
Amy Lara Sella. One more time, Amy Lara Sella. I am a newer hire of Standpoints, and my background and my focus while I'm here providing support to all of you lovely people is employment law. So, you know, that can mean any number of different things. And then basically other appearances or issues that are going to come up in the civil context. And there will be later webinars on a lot of the different topics that might interest advocacy as it relates to potential lawsuits against abusers or defending lawsuits from abusers on behalf of victims. That there will be a lot more resources coming out to help you all support the survivors you work with. But for now, and for purposes of this webinar, we're going to be focusing on how employment law and the issues that come up within employment really fits into the structure and the system of our courts here in the United States. You heard a lot from Raina at the beginning of this webinar about the difference between the federal court system and federal laws and the state system and state laws, and then how there's also an administrative process for a number of different issues that come up. Employment law is one of those fun areas where it can run the gamut and cross all of those various arenas. So I'll get into this just a little bit with all of you with the full understanding that this is not going to answer all of your questions and that there will be more to come. So fundamentally, employment law is really controlled and enacted through both federal and state law. And actually in many cities, there's also municipal code labor laws that come into play as well. So depending on where you live, it could be any number of different protections that employees have. This handy little chart here ultimately shows a number of a few of the options of the laws that protect employees: the Americans with Disabilities Act, the Age Discrimination and Employment Act, Title VII of the Civil Rights Act, which for those of you that are familiar with Title IX, they're part and parcel of the same legislation, the Civil Rights Act of 1964, that ultimately protect the civil rights of victims of certain crimes and in certain arenas. Title VII is the employment branch of the Civil Rights Act. There's the Equal Pay Act, and then here in Minnesota, we have the Human Rights Act as well. And to remind you all, there are also municipal codes that come into play in both Minneapolis and St. Paul and a number of other cities in Minnesota. Generally speaking, these laws are not going to conflict with one another. It's rare for that to happen. However, they can protect different things. So it's sort of a common understanding that in Minnesota in particular, we actually have a very strong Human Rights Act, meaning an employee is more protected under the Minnesota Human Rights Act than they are under Title VII. And the reason I mention this just briefly is oftentimes when I've been advising survivors who also have issues of sex or gender discrimination in the workplace, or let's say they work with their abuser who is discriminating against them in the workplace as well, I oftentimes will steer them towards the agency that oversees the Minnesota law simply because it's more protective and is typically a better venue for survivor plaintiffs. You can go to the next slide, Raina. So as I said, we've got both federal, state, and then also in some instances city laws, which also mean that we have different agencies that are tasked with overseeing the enforcement of those laws. Like I said, we have a hybrid of administrative hearing processes, then also potential for either state or federal court processes. This is where it gets complicated, and I'll go into it with you all, but just know that you can always give me a call if any of this is ever coming up with the work that you're doing with the survivors you work with. So the Equal Employment Opportunity Commission is the agency that enforces Title VII and other federal employment discrimination laws. That's one of our main agencies. The second main agency that you might encounter is the Minnesota Department of Human Rights, and they enforce the Minnesota Human Rights Act, so state law. There are also, like I said, city agencies in some cities. Minneapolis has one, St. Paul has one, that are tasked with looking at the anti-discrimination municipal codes. So you can also file complaints with those agencies should that come into play. The important thing here to remember is that you have to start at one of these administrative agencies and file a complaint within that administration before you ever have the option of going into court and filing a lawsuit against somebody for employment discrimination. We call it exhausting yourself of administrative remedies, basically because this process was set up to even the playing field between employers and their employees. As I know we're all very familiar, employers oftentimes have a lot of power, and so these agencies and these laws were put into place to try to level the playing field and allow an employee a space and a venue where they could have a better chance of proving their case, being offered protection, and have somebody working on their behalf. I will say, though, these venues are neutral arbiters of the law. So while they do conduct investigations into the allegations that somebody might make about sex or gender discrimination, they are not the representative for the victim or the party. They are administrative adjudicators. And so in addition to just having to file with one or the other first, I just want to make you all aware you shouldn't be filing with both. Both of these agencies have agreements with one another that they will allow people to, or claims to be, what we call cross-filed, meaning there aren't going to be two processes looking at the same situation. They've agreed that either of these two agencies can look at any of these situations as it arises under either the Minnesota Human Rights Act or Title VII. So basically you just get to pick one, and then that investigator will alert the other agency that this complaint has been filed. And ultimately the intake process is very similar. You know, they ask the same kinds of questions. They try to gather the same kind of information to see if there's a potential claim, and then they will investigate it similarly as such. Ultimately, the other thing that you may want to let your clients know about is that you don't need an attorney to be part of this process. You don't have to have representation as you're going through it because there is a process already in place. That being said, many plaintiffs do appreciate having an attorney, and it can be helpful if you do believe that you're going to end up in a court of law after this administrative process is done. It can be very helpful to have an attorney with you the entire process, ensuring that the record and the arguments that are being made are ones that are also the same ones that will likely be used when you're in court. Next slide. Maybe next slide. Possibly, if Raina's computer is not frozen.
I can't sit on my side.
Yeah, I could also be frozen too. That's all right. Well, I assume hopefully people have the PowerPoint in front of them. So this handy little chart is from the Minnesota Department of Human Rights, and it's a flow chart of how they handle their cases. So they basically do the intake where they have a certain set of criteria that they ask questions about that you would submit in writing, and then they determine if there's enough there that the law that's protecting discrimination is triggered, and then they conduct an investigation. This process is very similar on the federal side as well as in the city side too. So this kind of understanding, this flow chart, is going to be pretty controlling in many situations. The one difference that I want to make clear to everybody, because this is very important, you have a very small window of time to file with any of these agencies. So the clock starts running from the date of the incident, whether it be a firing or such aggressive sexual harassment that somebody quits, or maybe a demotion or a poor performance review. As soon as that thing happens, whenever that incident happens, the latest of which, if it's a sexual harassment ongoing kind of incident situation, you only have 1 year to file with the Department of Human Rights in Minnesota. You have anywhere between 180 to 300 days with the Equal Employment Opportunity Commission, and it's within 1 year if you're filing, say, with Minneapolis, with their Civil Rights Department. So I say this because a lot of the time these things it takes time for people to process. It takes time for people to get back on their feet. These windows are so small that they can be really really problematic, especially when we're dealing with survivors of violence at the same time. Because if you don't make it within that time limit for filing with one of these agencies, that also means that you're barred from bringing your lawsuit against somebody in court, because you have to go through the agency first. So there are some things that might toll that time period from continuing to run. Say if the person or the person committing the discrimination is out of the country, or they're out of the state. I mean, there are things that might change that timeline a little bit. And so if there are questions about that, feel free to give me a call, or I can connect folks with attorneys too to answer these questions. But the general rule of thumb is that it's anywhere from 180 days to up to a year, depending on which administrative agency you're working with. So once they take in the complaint, they'll conduct an investigation. That investigation might mean going over emails or key documents. It could be identifying and interviewing witnesses to the discriminatory acts, whatever information they deem necessary, which oftentimes is also the same information that somebody would use in court. Then goes into the arbiter's opinion, and they issue a determination. Oftentimes they may say, I don't believe that there's discrimination that happens here, but that doesn't preclude you from then taking that case to court. So even if you have a notice or a determination that no probable cause existed, that there was discrimination, you still then have the option of filing your lawsuit. So this is just sort of the first stop. There's also a process here where some parties can resolve their charges through settlement and conciliation. In particular, if you're working with survivors of domestic or sexual violence, this is something where it does involve the other party being present in the same room. And so there are some things that you might want to think through in terms of safety planning and just helping them to process the kind of trauma that might arise from a settlement or a mediation arrangement. So basically, that's just kind of the process. We'll flip to the last slide here, and I'll just kind of give you the main points, because that's, I know, a lot, and I also didn't even basically scratch the surface of what we could go into on the employment side. But ultimately, the takeaways here are it's complicated. You have something that starts as an administrative agency process that then very quickly has to move into either state or federal court. And so then all of a sudden you're back looking at those trial court levels, and then you can take it all the way up depending on what the circumstances of the case are. And oftentimes those cases are impacted by what goes on down at the administrative level. So ultimately, all I can say to you is if you have questions or if people have issues that are arising in their jobs, even if it's not necessarily something that you would think would be sex or gender discrimination, feel free to give me a call and I can talk it through with you and make a determination about whether a possible claim should be filed. I imagine the most common kind of claim that all of you will be seeing will be sex or gender discrimination, but please know that there are a lot of other protected classes too, like disability, age, sexual orientation, religion, any number of things that a survivor of gender-based violence might also be experiencing discrimination as it relates to that. So feel free to reach out. And also know that I'm a resource here when it comes to just navigating some of these tough conversations that employees have to have with their employers. Let's say if they get an order for protection and their employer is not interested in looking at it, how do you work to keep your job and keep your stable income while also making sure that the employer is honoring the need for protection, those sorts of things. So with that, I can answer any questions that folks have or tune into one of my future webinars.
There aren't any questions, Amy.
Good deal. With that, Rena, we'll turn it back to you.
All right. So last chance if anybody has any questions. And as people type, I will talk. Thank you all so very much for joining us. Again, if you have any questions around how the legal system, both the court system, prosecutors, law enforcement, how any of that stuff interacts with each other or how it works, whether it be on the administrative side, on the federal side, on the state side, please always feel free to give us a call. We are here to support you guys, to support the advocates in the state of Minnesota, whether it be about systems questions or law questions. We have advocacy here to help you with your advocacy questions. So remember, we are here as a resource for you. Ty, did we get any additional questions?
No, we did not.
All right. Well, thank you all so very much for joining us. I believe there is a evaluation that pops up afterwards, right, Ty?
Yes, there's a short evaluation, just 4 questions and 4 very important questions.
Yes, please, please, please fill out the evaluation questions. And as always, if you guys need anything from us, please let us know. Otherwise, thank you for all the fantastic work that you do. You make Minnesota a safer place, and we appreciate all of you. Thank you so much.